Welcome to Justice at Work, Employee Rights and Protections in the Workplace.
Welcome to Justice at Work, real talk from Filipados PLLC. I'm Evan Mack, and I'm here with Ananda Chaudhary from Filipados Law. We're fighting for fairness in the workplace. It's more than a profession, it's a mission. Each week, we break down the rights you didn't know you had, the system stacked against you, and the legal paths that can set things right. Whether you're facing discrimination, harassment, retaliation, or injustice on the job, we're here to help you understand your power and how to use it. Today, we're talking about microaggressions and subtle bias and when everyday behavior crosses into legally actionable environment. Sir, welcome. How are you?
How are you doing?
I'm well. I'm well. So now let's get right to it. How do microaggressions and that subtle bias tend to show up in the workplace?
Microaggressions can show up in a number of ways in the workplace. It can be as subtle as you always being interrupted in meetings, um, not being asked to participate uh, in group events. Um, s- subtle things like not learning somebody's name, not learning how to pronounce somebody's name. I've had cases where they can get, microaggressions can trend to more serious things. Like I had one case where one coworker just always asked to touch another coworker's hair. I mean, it's and
Mm,
and strange things like that.
yeah.
Um, it can be, it can be things like something that I get, like somebody asks me where I'm from and I say Boston and they'll be like, "Where are you really from?"
Yeah, where are you really from,
"You're
girl?
really from Boston." But then, sometimes it can be this is the weird thing about microaggressions. Sometimes that happens to me and it's actually I perceive it as a friendly conversation of someone trying to get to know me. And other times I know what they're thinking, that they want to see, like, am I one of them and how do I fit into their worldview? And so the question is, when do microaggressions become a legal problem? And there's really two aspects. There is, when does the microaggressions turn into a hostile work environment? And that is one thing that's related to, do the microaggressions arise to the level that a court will find that the company or executive or person making the microaggression has violated the law? The second thing is, and this is more common, that the microaggressions are actually indicative of an underlying bias or discrimination in the workplace. And it ultimately leads to a negative employment action, such as being denied a promotion, termination, and things like that. So, if you want to deal with the hostile work environment, it depends on um, what law you're going under. So, different laws have different standards. Federal law is, you have to meet a severe and pervasive standard to show a hostile work environment. And so when you're talking about microaggressions, just by definition, they're not the more severe type of things that will create a hostile work environment, which are, you know, blatant name calling, overt sexual harassment, where one instance of that can violate the law. It's more pervasive. Is it something where, you've asked your coworker to stop and they continue to do it and continue to do it and continue to do it? And and also, it's on the face of the microaggression, can you tell if it's motivated by discrimination, right? That's another thing. Sometimes, you know, the the law doesn't prevent someone from being mean to their coworker or being rude to their coworker. It does prevent discrimination. So if someone is interrupting you or always talking over you or something like that, the question is that is that discriminatory or is that rude? Is it based on an underlying protected characteristic, or is it just rudeness? And so courts will look at all those factors. So the microaggression will be, was the person asked to stop? Did it continue after they were asked to stop? And how, looking at it from a reasonable person, how likely was it that it was motivated by discriminatory conduct? But when you look at state law, which is it has to negatively impact the terms and conditions of employment, or even New York City law, which it simply has to a worker simply has to be treated less well because they have a protected characteristic. Even the more subtle microaggressions can be actionable.
So I know what makes these situations harder to evaluate compared to more direct forms of discrimination, more overt, forms of discrimination.
Yeah, they make it hard to evaluate because one, it's not always clear, although it's not always clear whether it's motivated by discrimination. So I look at even my own life. It is so it is so subtle, and in some of my uh past careers, um uh even I'm confused. Even I'm like, is this like what's going on? And so um that makes it hard. That's one thing that makes it hard. You have to show that it is motivated by discrimination. Two, sometimes when you say what happens, um, uh, it it's hard. So it's difficult to characterize your. Uh, Clients often have a difficulty showing how a microaggression can lead to such an emotional impact, and I see that it does over and over and over again. But one thing you have to do is really tell the story of how the discrimination is ongoing to show that it has a real devastating emotional impact. And, sometimes when it's being interrupted or being talked over or even like backhanded compliments,
Yeah.
it's hard to, it can be difficult for a person to articulate why that is so hurtful. Um, and those are the two reasons. They're one, they're not at a level where like you know, I'll take an assault or something like that where um it's cut and dry that it's illegal. It's you have to create a narrative to show that it the microaggressions are based on discriminatory conduct and that they rise to a level where they impact the client emotionally.
So how does the law look at a repeated conduct over time when determining whether a workplace has become actionable for you?
Yeah, and there, especially under federal law, there's a sliding scale almost. So if there's one really intense discriminatory act, that can be actionable. But if there are repeated microaggressions over a long period of time, well, maybe one or two of those actions, one of the two of those discriminatory conduct is not actionable. If it continues over a period of time, then that can meet the threshold of discriminatory conduct that you can bring a lawsuit under.
So, and under what types of records or details tend to carry the most weight when someone is trying to show that pattern that you've been talking about?
The gold standard is reporting it to an HR department. And if you report the discriminatory conduct to the HR department, that will potentially give you another cause of action. So then, um, once you make a report, the employer or cannot retaliate against the person who makes the report, because that gives, regardless of whether there was underlying discrimination, if you a court or a jury finds that there was underlying discrimination, if you report that a coworker is committing microaggressions based on race or sex or gender or any protected characteristic, um, the company cannot retaliate against you. And if they don't stop it, it it makes a case much stronger. So the number one record that a person can do is make a written complaint detailing the microaggression, stating specifically that they believe it was motivated by some sort of bias, and providing it to their HR professional. That is the best thing that they can do. But and oftentimes people come to us while they're still employed. And that's what we help them do. We help them make the correct report to HR. But what often happens if someone doesn't come to a lawyer at that point is
Right.
they they people understand typically that retaliation is illegal, but they are fearful that they will be retaliated against if
Yeah.
they make that sort of complaint. And what happens sometimes is a client won't make a complaint. A client, this is a client, this is after the fact, after something really bad happens before we represent them. A client won't make a complaint. A client will make a complaint, but not attribute it to racial discrimination. And those may not be protected. It's less clear if you whether that's a protected communication. There's no magic words you have to say, but if an employee characterizes it as a personality dispute or something like that, it may not be protected. Um, so the typical fact pattern, and this happens so often, is that uh, the person being subjected to microaggressions will sort of understand from a subjective perspective that they are being discriminated against. Um, but while they're still employed and the job is going well, they are fearful to make a complaint, right? While they still think they have a future at their employer, where they still think like I'm being discriminated against, but maybe I can work through it. Um, but the reality is where microaggressions are indicative of deeper underlying discrimination, it's very hard to have a satisfactory job experience. So as it goes down the road and someone feels like, look, you know, these my work isn't being appreciated, my contributions are being objectively analyzed. The microaggressions are indicative of discrimination, and that discrimination is impacting how my work is perceived. And they get a sense of, wow, I'm gonna I might be getting fired. Things are going downhill. At that point, that is when um, we typically see more um, uh, forceful reports to HR when someone is sort of fearful of their job um, being terminated. They'll say, "Look, this is a result of discrimination." And so, if it happens at that point, it's much better if the report happens earlier while things are going well, otherwise well in your employment. If it happens later, then the factual issues become much more complex and disputed because in every discrimination case that involves a termination or negative employment action, the our client will say that they were discriminated against, and the um, negative employment action was the result of um, discriminatory conduct. The employer will have a pretext and say, no, there was a termination because the job performance wasn't good, that we were reorganizing the department, that it was just a layoff. We didn't need the person anymore. And so if the report happens early and the person and the client is generally having good performance reviews, and there's subsequent retaliation, it's a much better fact pattern. If it happens later, then while the uh, discriminatory conduct is involves negative evaluations of performance, then that becomes a harder fact pattern. So the short answer is the best thing to do, even if it might be uncomfortable, is to report microaggressions early to human resources while you're still otherwise happy and in your job. The second thing is sometimes there's contemporaneous written communications with coworkers or friends. The third thing, which is a double-edged sword, is sometimes there's recordings of, sometimes the person being discriminated makes recordings, and every state law is different. Some states require one-party consent, where the person recording just has to be a participant in the conversation. Other parties require two-person consent, where you cannot secretly record a conversation you're having with somebody else. And also, if it happens in the workplace, sometimes there are policies that prevent recording in work. And sometimes I've had cases where that has been used. There's clearly discriminatory or retaliatory conduct that's being that the client has caught on tape, and they were terminated for recording, basically, recording the conversation. And so those are typically the types of evidence: reports to HR, contemporaneous communications, and recorded evidence.
But so, Ananda, for someone, experiencing this kind of treatment but unsure whether it rises to a legal claim, what considerations can help them better understand the situation?
I think they should, first of all, have they made sort of any attempt to stop the conduct directed? Like sometimes a friendly conversation saying, "Hey, like, stop doing this. This is bad because." Um, I would say the consideration is it something that happens on a repeated basis? That is one. Two, is it affecting you emotionally? And three, is it an impediment to achieving your goals at work? And those are sort of the three factors to consider, whether it might rise to the level of unlawful conduct.
All right, Ananda, appreciate the time, sir.
Thank you.
Thanks for listening to Justice at Work, powered by Filipados PLLC. If you're dealing with workplace discrimination, harassment, or retaliation, or just want to understand your rights, visit filipadoslaw.com to schedule a consultation. And don't forget to leave a review, and subscribe to the show so you do not miss the next episode. Thank you so much, everyone, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.